You're listening to an Airwave Media Podcast.
Hello, and thank you for joining the American Revolution. This week, episode 361, Drafting the Bill of Rights. Last week, we covered the Senate's top priority, the Judiciary Act. This week, we look at the main focus of the House of Representatives during its first session, amending the Constitution to include a Bill of Rights. By far, the biggest complaint following the Constitution was that the proposed Constitution did not have a Bill of Rights. A majority of state ratifying conventions focused on this point and demanded that one be added. Massachusetts, New Hampshire, Virginia, and New York all explicitly called for a Bill of Rights. The Federalists in those states could only fight to make them suggestions rather than mandatory in order to get the Constitution ratified. North Carolina and Rhode Island still refused to ratify the Constitution, and part of their complaint at least was the lack of a Bill of Rights. Pennsylvania, which had ratified early and unconditionally, went on to hold an unofficial convention before the ratifying conventions in other states were complete, and this group also called for a Bill of Rights. The concept of a Bill of Rights had become an ancient bulwark of freedom in English history. The Magna Carta of 1215 limited the king's power in certain ways that were designed to establish a rule of law, and rejected the idea of an absolute ruler who could do whatever he wanted. The notion found its way into the English Bill of Rights in 1689, following the Glorious Revolution, also in England. The English Bill set out some basic principles that had become foundational to what most people thought were necessary for a free society. It rejected the idea that the king could suspend or ignore laws that were passed by Parliament. It also barred the king from levying taxes without the approval of Parliament. This was the basis for the colonial complaint of taxation without representation. The English Bill also guaranteed the right of free speech and to petition the government. It barred the king from keeping a standing army in the time of peace without Parliament's approval. It guaranteed Englishmen, well, at least Protestants, the right to keep arms. It also required jury trials in most cases, banned excessive bail or fines, cruel and unusual punishments, and fines or forfeitures before a trial. The colonists had used these principles as the basis for justifying their Declaration of Independence. These were the sorts of inalienable rights that the king had violated. Americans wanted to establish that these rights had to be protected above all else. All states had some statutory or constitutional guarantees for the protections of rights, although these differed greatly in their details. Most of these were created in 1776, when the states first declared independence, and some were based on the rights that were already written into their colonial charters. The Articles of Confederation did not have a Bill of Rights. This was because the authority under the Articles was so limited that it was thought to be unnecessary. But when the Confederation Congress established the Northwest Territory, it did build a Bill of Rights into the Northwest Ordinance. Many of the leading Federalists, including Alexander Hamilton, James Madison, James Wilson, and Oliver Ellsworth, opposed a Bill of Rights. Their opposition was not based so much in an opposition to the principles in those potential bills of rights. Their concerns really had more to do with the fact that any delay or changes to the Constitution by adding a Bill of Rights would sink or at least greatly delay the ratification process. They also did not want a second constitutional convention for the purpose of adding a Bill of Rights because they also feared that the Anti-Federalists might hijack that convention and make a whole bunch of changes to the original Constitution that had been established at the first convention. But even beyond these strategic considerations, leading Federalists argued that creating a Bill of Rights was a bad idea. For starters, they argued that the U.S. Constitution was the same as the Articles of Confederation in that it only gave the federal government certain enumerated powers. Unlike states that had all sorts of potential powers, what we would call today the general police power, the federal government could only act in those areas that the Constitution specified. So, for example, there was no worry that Congress could pass a law that infringed on the freedom of speech or press because there was no enumerated power in the Constitution that allowed Congress to have that power. Hamilton wrote in one of the Federalist Papers, "Why declare things shall not be done when there is no power to do?" The Federalists also argued that there was an affirmative danger in listing a specific Bill of Rights. Once they defined those rights, they were concerned that they might inadvertently leave some right off the list, leading to the implication that the government might infringe on that overlooked right. Some also argued that the Constitution did nothing to repeal the various rights protected by the state constitution, and that the people still had those protections. Beyond that, men like Madison believed simply that writing down certain rights was essentially meaningless. He referred to them at one point as, quote, parchment barriers. A majority, in what he called popular hysteria, might approve taking away some of those rights. That had already happened many times at the state level. Simply having a right written down on paper that the government did not recognize and that voters did not care about was essentially meaningless. The protection of rights comes from the demands of the people and the obedience of the government to those principles. James Madison had been a leading opponent of the Bill of Rights at both the Constitutional Convention and throughout the ratification process, mostly for the same reasons I just addressed above and which most Federalists agreed with. They were an unnecessary distraction from creating and implementing the new federal Constitution. However, by the time Madison had taken his seat in the new U.S. Congress, he had changed his views on this topic. Patrick Henry and other anti-Federalists in Virginia saw Madison as dangerous. They tried to keep him out of the federal government completely, first denying him an appointment as a senator, then drawing congressional districts to put his home in a strongly anti-Federalist district. When Madison entered the election contest against James Monroe for the seat in the House of Representatives, he knew that his voters were not happy with his Federalist tendencies and were inclined to vote against a representative who would push for a stronger federal government. So Madison did what any politician fighting for political survival would do. He flip-flopped. Okay, I may sound a bit cynical in saying that. We generally think of a flip-flop as completely changing one's view on an issue of principle. As I said before, Madison never objected to the fundamental principles that a Bill of Rights would protect. He simply saw it as an unnecessary distraction. With the ratification process behind them, a Bill of Rights would not impede the implementation of the Constitution. In fact, if he could introduce a Bill of Rights on his own terms, it might take away some of the political pressure to hold that second constitutional convention. Even as late as August of 1778, Madison was still pushing the Federalist line that a Bill of Rights taken up by the first Congress would be a distraction. Madison called for having a few years without the bill so that there would be some experience as to exactly what rights should be protected. But as his election heated up, Madison changed that view. In a letter in the fall of 1788, Madison candidly admitted, in a letter to Thomas Jefferson, that he was fine with a Bill of Rights if it was done properly, but that he mostly favored it to satisfy others. Quote, "My own opinion has always been in favor of a Bill of Rights, provided it be so framed as not to imply powers not meant to be included in the enumeration. At the same time, I have never thought the omission a material defect, nor been anxious to supply it even by subsequent amendment for any other reason than it is anxiously desired by others." Jefferson strongly encouraged Madison to support the Bill of Rights, not only out of political expediency, but because such, quote, parchment protection, as Madison called them, did make a difference. While Jefferson conceded that popular governments might still violate rights in some cases, writing out those rights would help to protect them. In particular, it would give the judiciary more ammunition to protect those rights against the popular will. So while Madison's interest in creating a Bill of Rights was mostly about satisfying other people who wanted one, he did decide that he had to make it a priority. He made his new views public in a letter written on January 2, 1789, to a local Baptist minister, George Eve. Madison wrote in part, quote, "It is my sincere opinion that the Constitution ought to be revised, and that the first Congress meeting under it ought to prepare and recommend to the states for ratification the most satisfactory provisions for all essential rights, particularly the rights of conscience in the fullest latitude, the freedom of the press, trials by jury, security against general warrants, etc. To further his point, Madison wrote another letter to Thomas Mann Randolph a couple weeks later, which he knew was going to be published in the newspapers a few days before the election. In it, Madison reiterated his willingness to amend the Constitution. Quote, "The report, which I have reason to believe is most injurious, charges me with being a strenuous advocate for the perfection of the Constitution as it stands, and an inflexible opponent to the change of a single letter. The truth, on the contrary, is that I have ever thought it might be improved in several points, although I never could see the dangers which alarm many, and what is more, was an unsuccessful advocate in the General Convention, which framed the instrument for several of the very amendments, since recommended by this and other states." He continued, "It is particularly my opinion that the clearest and strongest provision ought to be made for all those essential rights which have been thought in danger, such as the rights of conscience, the freedom of the press, trials by jury, exemption from general warrants, etc." He also argued in favor of amendments rather than a second convention. In this point, he argued that it would be much faster and easier to get these changes into the Constitution through the amendment process. In short, Madison not only supported a Bill of Rights, he made clear to his voters that he made it a top priority and promised them that he would personally initiate these proposed amendments right away when he got to Congress. Madison's motives were not simply to win the election. He had also come to realize that so many people were demanding a Bill of Rights that it was probably inevitable. By leading the fight to create the bill, Madison could make sure it was done the way he wanted, and could also be done in a way that avoided that dreaded Second Constitutional Convention. After winning his seat in Congress, Madison focused on producing a draft Bill of Rights. I use the word focus cautiously because Madison really was doing a host of other things at the same time, including writing President Washington's inaugural address, helping to get the president's residency set up in New York, and many other things. Despite his other works, Madison had promised his constituents to make the Bill of Rights a priority, and he did just that. He got to work researching what should go into it. In his research, Madison relied heavily on the Virginia Declaration of Rights, which had largely been written by George Mason in 1776, although others, including Madison himself, had played a role in drafting their final version. Madison also went back to the classic English documents like the Magna Carta, the English Bill of Rights, and the works of the philosopher John Locke. Madison also used contemporary resources. He reviewed all the state constitutions to see what those documents considered to be the most important protections. He also consulted all of the proposals drafted by the various state ratifying conventions, and of particular concern to him were the proposals made by the voters of Virginia. The various conventions, along with the reports from the minority committees in states that did not formally propose amendments, totaled over 200 changes to the Constitution. Now, of course, many of these were duplicative, but even after removing all the duplicate requests, Madison came up with a list of about 75 distinct amendments. Although Madison consulted a great many documents while drafting his proposed amendments, he did not seem to consult with many people during this process. He had corresponded with Thomas Jefferson and others about whether to add a Bill of Rights. He also showed his final proposal to George Washington before submitting it to Congress, but he did not seem to work with anyone else when he drafted the specific proposals that he planned to introduce into Congress. Madison, of course, expected that once he introduced his proposals, that Congress would tear into them and make plenty of changes. This was the same thing that happened to him when he introduced the Virginia Plan to the Constitutional Convention. But by presenting a completed proposal, Madison would at least control where the debate began and hopefully prevent it from moving too far afield. His goal was to draft a comprehensive list of all the major concerns raised by the states and on which there was a general consensus. He wanted the focus to be on an expression of protected rights. Madison did not want the debate over amendments to veer into a discussion of substantive changes to the Constitution itself. He viewed this as more of an addition or supplement to the original Constitution, not an effort to rewrite the whole thing. Madison still saw this effort as substantively meaningless. He already believed that the Constitution, as written, did not give the federal government the power to infringe on the basic liberties of the people. This was an effort to keep his constituents happy and to satisfy the anti-federalist complaints that the new Constitution did not protect these rights. As a result, he simply compiled a list of various rights that people had. He didn't really try to make any effort to create a system for the federal government to protect those rights or any sort of enforcement mechanisms or procedures for the people to use when the government overstepped its bounds. Madison noted states had all provided different protections. For example, 5 states had established religions or permitted an established religion in the state. 5 also did not provide for the protection of rights of assembly, petition, or the right to counsel or trial by jury in civil cases. 2 states did not say anything about a free press. 4 states had no restrictions on things like excessive fines or bail, self-incrimination, or the need for search warrants. The majority of states had no problem with an ex post facto law or double jeopardy. Most did not require grand juries. Only a couple explicitly provided for the freedom of speech or a prohibition on double jeopardy. Madison's main focus in these amendments were to ensure that the federal government would not infringe on the rights of people. The goal was not to ensure that states would not infringe on the rights of people. Madison knew that if he tried to empower the federal government with the power to prevent states from interfering with the rights of the people, that could lead to a backlash from the anti-federalists about allowing the federal government to interfere with state powers. Now, as we'll see, he did propose one amendment that would do this, but his main focus was on limiting federal power. Each state would continue to have full authority to establish its own rights and was obliged to protect them on their own. Madison's primary concern was making sure the federal government would not infringe on his list of rights. Now, Madison believed that the best way to preserve these rights was for the people to be on the watch at all times for a government that might infringe on them. Beyond that, the separation of powers that was spelled out in the original Constitution should prevent fleeting majorities who might elect someone who would run roughshod over their rights from ever gaining sufficient power to put all of those violations into effect. In his final proposal, Madison did add a few substantive restrictions. He added a rule that would increase the size of the House of Representatives so that there would be one representative for every 30,000 voters. There had been a push for this rule at the Constitutional Convention, and several states, including Virginia's ratifying convention, had demanded such a rule. Madison also added a rule that members of Congress could not increase their own compensation prior to an intervening election. In other words, members of Congress could not get into office, give themselves a huge raise, and take that money before the voters had anything to say about it. Any raise would take effect in the next Congress after the next election, giving the voters a chance essentially to approve that pay raise. Madison did not carefully number his changes, so if you count them differently, most people will say there are about 15 to 20 amendments in his initial proposal, although he did seem to number some of them. He came up with the number 9, but I'm going to go through some of the main ones that he wanted to cover. His main issues were freedom of religion, free speech and free press, the right to assemble and petition government, the right to keep and bear arms, the right not to have soldiers quartered in people's homes, protections against double jeopardy and self-incrimination, the right to due process, protection of private property, prohibitions on excessive bail or fines, prohibition on cruel and unusual punishments, protections of searches without probable cause or specific warrants, and the right to a speedy trial, where the accused is informed of the charges and has a right to confront accusers and bring witnesses. Recalling his concern that a list of rights might allow people to claim that this list is finite, Madison also added a clause that his list should not be construed to diminish the other rights that were not mentioned. Madison did, as I said, put a few restrictions on states. He added a clause that no state could violate the rights of conscience, freedom of the press, or trial by jury in criminal cases. He also proposed rules that would prevent appeals to federal court if the value was below a certain amount, or that appellate courts could reevaluate the facts of a case that had been decided by jury. He also added rules for grand juries and capital crimes, and that jury verdicts had to be unanimous, and that trials had to be local. Finally, Madison added an explicit rule that the legislative, executive, and judicial branches could not try to exercise the powers of the other branches, and that any powers not delegated by the Constitution nor prohibited to the states continued to belong to the states. So that was the set of proposals that Madison brought to Congress in the summer of 1789. Next week, we'll discuss what Congress did with those proposals. Hey, thanks for joining the American Revolution Podcast After Show, part of the Airwave Media Network. Thanks to my Patreon supporters in the Alexander Hamilton Club, George Davis, Mike Hager, John Celentano, Michael Mulhern, and Mitchell Anderson. Thanks to Robert Morris Circle supporters, Chasen Harrison, and Gordon Kemp. I really do want to thank everyone who supports this podcast financially. It really is thanks to your generous support that I'm able to keep this podcast going. If you're not a subscriber yet on Patreon, please consider supporting me. If you can, for as little as $2 a month, you get access to commercial-free episodes. If you can support me at the $10 level, I will send you a token of my thanks each month with a different flag from the Revolutionary War. I also wanted to mention real quick, we are going to hold an August roundtable this week. Ordinarily, we skip roundtables in July and August, but author David Price has a new book about the 10 crucial days, which he wants to discuss with us. You will need to be on my mailing list or join as a member on Patreon. Even as a free member, you will get invitations to these live roundtables. We have some great discussions scheduled for this fall, so don't miss out. Now, this week, we covered James Madison's conversion from Federalist to a Democratic Republican. These are the two parties that would build up over the next few years. Many people ask how Madison was such a leading Federalist and the person who pushed for a much stronger federal government in the Constitution, only to align himself with the party that eventually evolved into the Democratic Republicans. This is the party that most anti-Federalists joined in the coming years. Madison's move away from the Federalists and the Federalist Party was sort of a gradual one. The big change we covered this week was Madison's decision to move from being an opponent of a Bill of Rights to not only a supporter, but its primary author. The clear reason for this was that his position in favor of a Bill of Rights was critical to his election as a congressman in the gerrymandered district full of anti-federalists. I use the term gerrymander guardedly as well, since that term did not come into use until 1812, when Massachusetts Governor Elbridge Gerry created a special district that was shaped a bit like a salamander in order to benefit his party. But the idea of drawing districts to favor or disfavor a certain party is probably as old as elections themselves. Certainly we see it going on in Virginia in 1788, with Madison's district being filled up with mostly anti-federalists and also including a strong opponent in James Monroe. Playing political games with districting is nothing new. So Madison had to move toward the anti-federalist position because of his voters, but he did not just change all of his views overnight. First, his constituents' demands that a Bill of Rights focused him on the concerns that many people had raised across the continent. Although he considered a Bill of Rights unnecessary as far as federal power, he did see the benefits in mollifying those voters everywhere who wanted some statement of rights that were to be protected. Thomas Jefferson, who would become Madison's close political partner over the coming years, played a big role in convincing Madison of this. Even though Jefferson was still in France at this time, the two men corresponded. Jefferson recognized the importance of satisfying the concerns of voters on this issue. Even if we're cynics and we might think that Madison just changed a principled position for political expediency, I don't think this is the case. If it was, we'd expect to see Madison move back towards federalism, especially after he gave up his House seat in a few years. That was not the case. As we'll see in future episodes, the Federalists continued to move in the direction of creating a more and more powerful federal government through issues that had not come up yet, like the Bank of the United States, and more federal support in industry and manufacturing. These were not big issues before this time, and when they did become issues, they divided Madison from other Federalist leaders like Alexander Hamilton. Another huge break that we will hopefully cover in some future episodes was the passage of the Alien and Sedition Acts. These helped seal the division between the Federalists and the Democratic Republicans. These laws were passed in the late 1790s. The Sedition Act pretty clearly violated the First Amendment by outlawing criticism of the president. The Alien Act, which has been in the news recently, gave the president extraordinary power to target and detain people in the U.S. who are citizens of a country that is at war with the U.S. Madison and other Democratic Republicans believed these laws to be unconstitutional. This debate went a long way toward hardening the differences between the two parties. As we'll also see, Madison definitely chose the winning side as a Democratic Republican when this party went on to dominate national politics, while the Federalists became a minority party that had very little success outside of New England. I had a hard time deciding on a book recommendation this week, and that's because there's a bunch of really good books on this topic. I've listed a whole bunch of them at the bottom of my blog episode for this week, but the book I seem to keep going back to again and again for answers was James Madison and the Struggle for the Bill of Rights by Richard Labunsky. It covers Madison's entire journey from the Constitutional Convention in Philadelphia, through the Virginia Ratifying Convention, through his election against James Monroe, covering then the adoption and ratification of the Bill of Rights. So this book kind of takes you through the entire process. There are also appendices at the end of the book that show you the various versions of the Bill of Rights as they went through Congress. So it's a very interesting read on the evolution of the Bill of Rights. The author was a professor at the University of Kentucky when he wrote this book back in 2006. He has since retired, but if you want to read more about how Madison and the Bill of Rights itself evolved through this process, you should get a copy of James Madison and the Struggle for the Bill of Rights by Richard Labunsky. My online recommendation is an online article from National Affairs entitled Madison's Consistency on the Bill of Rights. And this goes through the political decision-making process that Madison went through from being an opponent of the Bill of Rights to becoming its most ardent supporter. It's a good summary of the issues we discussed this week, and as always, I've included links on my blog and website. My question this week asks, was the Constitutional Convention illegal? Well, I guess that really depends on your perspective. If we accept that the Articles of Confederation were the relevant law at the time, the Articles didn't really address the idea of holding a convention, but the Confederation Congress did approve the convention for the, quote, sole and express purpose of revising the Articles of Confederation. Many people argued at the time, and probably today, that creating an entirely new form of government went well beyond merely revising the Articles. But I guess you could consider a complete rewrite to be a form of revision. What gets really controversial is the ratification process spelled out in the Constitution itself. Under the Articles of Confederation, the sorts of changes proposed by the Constitutional Convention would have required the unanimous consent of the Confederation Congress. And by that, I mean the consent of a majority of each state delegation. Instead, the delegates to the convention wrote into the Constitution the process for state conventions to ratify it, and that it would go into effect once 9 states had ratified. If we're calling the Constitution a revision of the Articles, it would seem that the process of ratification violated the rules for amendments that were set up in the Articles. The Confederation Congress, however, did not seem to make any effort to object on these grounds. Once 9 states had ratified, the Confederation Congress followed the process laid out in the Constitution, ignoring the Articles of Confederation, and began implementing the new Constitution. The vote in Congress was not unanimous. Only 9 states voted to begin the process of implementing the Constitution. So, while I would not say the convention itself was illegal, the process it invented to ratify the Constitution did pretty clearly violate the rules under the Articles of Confederation. The Articles, however, had no court system, so the only place to raise this issue was in the Confederation Congress itself. They chose not to oppose it. Why? Even the current delegates realized that the Confederation Congress had become ineffective. The convention had most of the leading political leaders of the country present, most especially George Washington. His presence carried inordinate weight. There was a general consensus that change needed to happen and that the newly proposed Constitution was the best opportunity to make that change. So even though some states argued strongly against this process, most notably Rhode Island, the majority of states just went ahead and created their own rules. At the end of the day, let's face it, laws are just words on a piece of paper. What gives them power is society's willingness to accept and enforce them. In this case, the overwhelming majority of leaders and people seemed to think that we needed a new set of rules, and they implemented them. This wasn't even the first time this happened. After all, the decision to declare independence also violated British law, which was the relevant set of rules at the time. At least in the case of overturning the Articles of Confederation, there was not an enemy army trying to oppose the change. If you have a question you'd like me to answer, please reach out to me, either via email or on X, Facebook, Quora, or Reddit. Well, that's all for this week. I hope you will join me again next week for another American Revolution podcast.